Yes, okay.
And as Roxanne said, I'm Clark Bormann, and I'm glad to answer questions. If I speak about something that does raise a question, I'd just as soon have you ask that right then and there. Raise your hand and we'll talk about it. Then you don't have to worry about what was I going to ask him and where does it fit in all of this. And it doesn't bother me if you ever come up and get some more snacks. That'll be fine with me. My name is Clark Bormann. I live here in Bismarck. I was born and raised in Mobridge, South Dakota. My dad was a lawyer, and my mom's dad was a lawyer there before me, so I'm a third-generation lawyer. In the small town of Mobridge, it was kind of neat. Grandpa had a case that went all the way to the United States Supreme Court. He was representing the fellow who owned the ferry at Mobridge, crossing the Missouri River, and they were starting to build a highway bridge. So his business was destroyed, and so they sued the state, and the state said, no, we're not going to pay you a dime, and Grandpa took it all the way to the United States Supreme Court. The opinion was written by Taft, former President of the United States, now Chief Justice, and one of the people that Grandpa got to argue to was Oliver Wendell Holmes Jr., who had spoken to Abraham Lincoln, and had been, in the Battle of Gettysburg, a very cool history. But anyway, after about 10 years, my wife has a master's in special ed, and there were more opportunities here. I wanted to do more trial work, more opportunities in a bigger city. And our daughter, we were driving her up here for violin lessons every weekend for 2 hours up, half-hour lesson, and 2 hours home. So for all three of us had a good reason to consider moving to Bismarck. And we've been here since 1978. So I've been a lawyer for 45 years. I'm trying to semi-retire, which I was mentioning means 6 days a week, but that's where we're at. My law firm has Ross Espeseth, who is a lawyer, been here for years, Paul Meyerchin, and Chris Edison, and Katie Winbauer, and then we have a new young lady joining us here in the fall. She'll be taking the bar exam in the summer and then joining us in the fall. So we're a 6-person law firm. With good staff and good experience, and that's a little bit about us, about me. I'm happily married for 48 years now, and our daughter Catherine plays the violin in the Cleveland Orchestra in Cleveland, Ohio. So she did stick with the violin. I want to talk a little bit about initially just estate planning in general, and then we'll talk in particular about special needs trusts and able accounts and that kind of thing. But initially, most people think estate planning, I don't have an estate, why do I have to worry about that? I do recommend that people keep in mind that it's important to have at least 3 documents: a will, a healthcare directive, and a durable power of attorney. I think those are really critical. If I work with people, I always say, if you're here, let's talk about a will, because then you can decide what will happen when you pass away with your property and whom you name to be in charge and that kind of thing. The durable power of attorney is a lifetime document that works only during your lifetime. It basically says, I name my wife, but if not, I name my daughter to write my checks, pay my bills. If I had a stroke or something, it's seamless. My wife doesn't have to go to court to get appointed as a guardian or conservator. She can continue to handle all those business matters because she has the power of attorney. If my wife and I are in a car accident and both of us are in a coma, our daughter is the second in line on that, and she can just automatically pay our bills. All she has to do is show that power of attorney to the bank and say, here, I'm going to be signing checks on mom and dad's account. So those 2 documents. And then the third one is the healthcare directive. And that basically says, if I'm unable to communicate with my healthcare providers, then I name my spouse, in my case, and my daughter, if she can't, to make healthcare decisions for me. And that document is a good one because you can say, for example, this is what I think about what kind of service I want if I pass away. I can talk about where I want to be buried. I can talk about whether or not I want to be cremated, whether I want to donate body parts or not. And it also says that this is my thoughts about extended care. Do I want extraordinary measures if I am in a position where I'm dying and it's impossible to prevent that? Or if I've had so much brain damage that I'm incapable of ever regaining competence. And that one came out of the Karen Chavo case in Florida. You might remember a lady for 10 years was in a coma, and her husband wanted permission to reduce or eliminate the life support measures which were being used, and her family was against it. They said, no, no, she's squeezing my hand when I talk to her, she knows I'm here. They finally, I think that went to the United States Supreme Court, and they said, no, it's going to be up to her husband. And he did have her disconnected. She did pass away. They did do an autopsy, and they said that unfortunately her brain was so badly damaged, there was no way that she was competent. So it's, in North Dakota, we can sign a document, we can make that part of our healthcare directive to say that if I'm permanently unconscious, that you have the authority to eliminate the child support measures. So those three documents, will, healthcare directive, durable power of attorney, are very, very good things to have. A lot of people come in and they talk about trusts, and we'll talk about special need trusts, but trusts a lot of times come into play where they say, you know, I have some kids that aren't very responsible, and I don't really want them to be in charge of these assets if I pass away. And there's things you can do a trust during your lifetime, which is called an inter vivos trust. You can do a trust in your will, which is called a testamentary trust. And commonly, in my experience, what I'll do is, my will, for example, says everything to my wife. If she doesn't survive me, everything to my daughter. But if my daughter had died before us, leaving children, I don't know that I'd want everything that we've saved during our lifetime go to an 18-year-old boy, I'll pick on the boys, who's just going to buy a pickup truck and have a lot of fun. So I can do a trust in there that said, if my daughter should die before me, and if my wife has already passed away, I want to name my twin brother, I've got a twin by Buck, that if he could be the trustee, and that's the way our wills did provide it, that he would manage our assets for the benefit of our daughter. And in our case, we had it set up that he would pay for college, pay for tuition, music lessons, that kind of thing. But when she was 22, she'd get a third of what was in there. When she's 25, she'd get a half of what's left. And when she's 28, she'd get it all. Just thinking along those lines. 22, you're getting out of college or a trade school. 25, you're getting out of maybe graduate school or buying a house. 28, if you're not old enough, you never will be. But that's a trust you can establish in your will, a testamentary trust. People sometimes do them now during their lifetime with a trust. And then you can have two kinds of trusts there. An irrevocable trust, which means you can never change it. It's irrevocable. Or a revocable trust, in which case you can say, we're going to put our minerals into this trust, and my wife and I get the income for life. When we're gone, it's going to go to our daughter, and when she's gone, then it'll go to her kids, or our nephews and nieces if she doesn't have them. If it's revocable, we can always change it. Say, you know, when we're gone, we want it to go to charity, if our daughter isn't alive, or when she's done living on the income. If it's revocable, it does not protect it for Medicaid purposes. So my wife and I stroke and we go in the nursing home and we have to pay $12,000 a month each to live in the nursing home. All of those assets that are in there are exposed. We're not going to be eligible for Medicaid. We aren't going to get any benefits from the state. If it's irrevocable, we can't. And let's say, for example, we have some farmland. We put that into an irrevocable trust, and it says as long as we're alive, the income goes to us. When we die, then that property goes to our daughter, or if she's gone, to our grandchildren. If that's irrevocable, and it's been in place for 5 years, then my wife and I stroke and have an accident or whatever, and we're in the nursing home, we're going to be there the rest of our life. The state doesn't, we're eligible for Medicaid once we've burned up all of our other assets. That land is safe. It's in an irrevocable trust. So those are things that if you think about doing those things, sit down with a lawyer. There's a lot of good lawyers in this town, in this county, in this state. There's a lot of good lawyers that can talk to you about that kind of thing. And as I say, some folks come in and say, boy, I want a trust. I got to have a trust. And I ask them, why? Well, number one, I don't have to have a probate to pay those doggone lawyers. And, you know, that's true. If you put every single thing into that trust, then you can eliminate a step of probate. And I'll talk a little bit about what probate is. But the problem could be is that, you know, if you think about it, I can charge you now for doing that trust. And I don't have to wait for you to die and hope you come in and hire me to get the probate fee. So it's almost a benefit to me. Now, there's some cases where it's a perfectly good thing to have that trust, And I will write trusts for people, but there's many times when I say, you know, that may not be the best reason, just to avoid probate. Probate is not that big and fancy and expensive anymore. It can be a lot simpler and easier, and it may not be necessary when the first one dies anyway, but that's one thing. The second reason they say is, you know, because then I don't have to pay those federal estate taxes. And that's simply not true. Uncle Sam, if it's going to bite you, Uncle Sam will bite you now or it'll bite you when you die. One thing or the other, but Uncle Sam's going to get taxes. If your estate is big enough, and right now the size of your estate to have federal estate tax is $13.6 million for me and $13.6 million for my wife, or a total of $27 million before Uncle Sam gets a penny in federal estate tax. So most of us don't have to worry about federal estate tax, doggone it. And the practical matter, 1st of January 2026, that goes back to about $7 million and $7 million. But again, collectively, you have to have more than $14 million before federal estate tax kicks in. And the third thing people say about I want a trust is because I want privacy. When I die, I don't want to have anybody know what I own. And that is true. There is some merit to that. But the law changed. When I first started practicing law, we had to file the inventory and appraisement in an estate. Clark died. When he died, it became a public record. That inventory showed how many cars I owned, what they were worth, what my bank accounts were, what my savings accounts were, my investments. All that stuff had to be in the public record. Anybody could stop in the courthouse and see, what did Mary inherit when Clark died? What was his name on it? And now we don't have to do that anymore. The Uniform Probate Code changed that so that now, as long as I mail that to the heirs who are entitled to inherit, it doesn't have to be filed in the courthouse. So the privacy issue that you get from a trust is not necessarily that big a deal. It's really not necessary if the only thing you're worried about. Now, the other thing is, yes, my will, if I die and my estate is probated, my will is going to be a public record. All of you could go to the courthouse and say, I want to read that will. I'm not embarrassed about that. My will says everything to my wife, if not to my daughter, and if she doesn't have any kids, then we got nephews and nieces. I'm not embarrassed about it. I don't care if you see that. I'm telling you about it. But so I did have an uncle who was single, and he married late in life, but they both had their own income. And he had, I think there were 40 some of us nephews and nieces. He knew many of us, but there were, some that he didn't have any relationship with at all. So he put all of his assets into a trust. And that way, when he died, my dad and then I were the successor trustees. We basically could say to the 20 of us that were the beneficiaries of that trust, this is what Uncle owned, this is what we paid for expenses, and this is what your share is. And we didn't have to tell those other nephews and nieces that weren't involved what it was about. So they never knew. And they never will know. Some of the kids, unless some of them tell them. But to that extent, yeah, there's privacy. And Uncle Don had the benefit of having the privacy of knowing that, it was just the kids that were benefiting, nephews and nieces that he had a relationship with that got to that. So if there is a probate, if I died today, everything that I have really is joint tenancy or payable on death. My cars say Clark or Mary, so the title is automatically hers. Our house is Clark and Mary, husband and wife is joint tenants. If I die, all she has to do is record my death certificate and it's hers. My checking savings account, they're all joint with her. They're automatically hers. So the only thing is that I have an interest in law practice. She's not a lawyer. So she'd probably have to open my estate in order to probate my interest in that to pay it to her under the will. That's the only asset that would be in. But if she dies first, everything we have, I said, is joint. I won't have to open a probate when she dies. So I'm not worried about that. Yeah, I file a death certificate on the house to prove that she's gone and now it's in my name. I just go in and I can sell the cars because they have Clark or Mary on them. For checking and joint checking and savings, all I have to do is notify the bank and they'll just take her name off the account. It's mine. Life insurance is payable to the surviving spouse. So usually with married couples, when the first one dies, we don't have to have a probate. It's when the second one dies, and that's when you can start doing your estate planning. You go in and talk to your lawyer and say, okay, you know, I'm a widow or a widower now. Can we arrange this so that when I die, I don't have to have a probate? And it can be done. There are ways to do that. The trust is one way to do it. At that point, you may want to do that. Another one, especially on real estate, is you can say, I'm going to convey my house to my daughter, but reserve a life estate, which means as long as I'm alive, I get to live there. I got to pay the taxes, insurance, maintenance. But the moment I die, all she has to do is record the death certificate and it's hers. Or I could do a transfer on death deed, which says, if I still own this house when I die, she gets it. All she has to do is record a death certificate and the house is hers. That's called a transfer on death deed. The beauty tax-wise for both of those are, she gets what's called a stepped-up basis. So that no matter what I paid for that house, if I die and that house is worth $200,000 and she sells it for $200,000, it's free. She doesn't pay a dime income tax. That's one of the advantages of a transfer on death and a life estate deed. So those are things about probate that hopefully, you know, it gives you an idea of things to be thinking about. The process is not that difficult. Somebody dies, go see your lawyer and see, do you have to do something? Is there something we have to do? Just talked to a lady today, and it's very simple. Everything was joint, so all we have to do is record a death certificate. The real estate is hers, and the motor vehicles had both names on it. She doesn't have to do a thing on it. Yes?
What about single?
If you're a single person. Then some of the options are, again, the transfer on death deed or life estate deed on real estate. You can also say transfer on death deed on your accounts. You know, and that's not a bad way to do it. If you know I've got a child or children, I can put their names transfer on death so that the bank accounts will be theirs. The only risk there is that if you've got 3 kids and the transfer on death deed, the big asset, I have $100,000 in my account and I die and it goes, the bank is just going to pay those 3. Who's going to pay for the funeral? You know, because you might have one of those children say, I got my $33,000, you guys pay for the funeral. I'm not going to do that. Usually you don't run into that problem, but I have seen it, unfortunately. And, so that's one way to do it. I don't recommend you put the name on the car of one of your children, because then if you drove too late at night and you fell asleep and you ran into somebody, they might sue your child also, because your child's name was on there. Or vice versa, your child has a judgment against him or her, and they seize the car because the name is on it. So I don't recommend typically on cars. And let's say that if I died, everything is payable to my wife, except I do actually have my first car. It's a 64.5 Mustang. I think I've got Mary's name on it, but if I didn't, let's say that I just have my name on that, if it's worth under $50,000, that's the only thing that's in my estate probate, she doesn't have to open a probate for that. She can just go in and say, it's worth less than $50,000 and I'll take it, put her name on it. So there's a shortcut there. Can't do that with real estate, but you can do that with personal property. So that's kind of the process there. Now, most of you are familiar with Medicaid. Medicaid's a state program, state and federal, but the state operates it and basically provides medical assistance for people who meet certain needs categories. And typically, if you have a disability before age 26 and you are eligible for Medicaid benefits, then you can only have so many value of assets in your own name. And for Medicaid, that value is $3,000. So if I'm under 26 and I have a development disability, for example, if I have a $5,000 savings account, I'm not going to be eligible for Medicaid. I got to get that spent down. Once I'm down $3,000 in assets, I might be eligible for Medicaid and other benefits that the state provides that give assistance to people who have disabilities. The Special Needs Trust is one way to establish a means by which you can say, I'm going to put money into a special needs trust, and no matter how much money I put in there, it's not going to count on that $3,000. So it doesn't disqualify them for Medicaid. There's certain provisions, requirements for the special needs trust, and usually they have to be, it's for blindness or disability that occurred before age 26, And then you can fund that, and if you fund that with your own money, let's say my daughter had a special needs and I created a special needs trust for her benefit. That's my money. I can say in that trust, as long as she's alive, and we'll talk about what you can do with that, this money is available to enrich her life or to improve her life situation without endangering her eligibility for Medicaid or other benefits. So if it's my money in there, I can say when that trust, when she dies, I will say where that money goes. What's left in there. If there's any money left, I can say it's going to go to my nephews and nieces, or it's going to go to a charity, or whatever. But if it's her money, let's say that she was in a car accident and has funds of her own as a result of the injury she sustained in the car accident, and that's her money. That then is called a self-settled special needs trust. Now that money, again, it can go into a special needs trust, provide to improve and increase the benefits to her lifetime, provide benefits which the state or Medicaid programs do not provide. But when she dies, that money has to go back to the state. To the extent that the state paid money for Medicaid benefits, for medical needs and that kind of thing, the state has the first claim on that. Which is really not unlike, frequently you run into the case where mom and dad are aged and one of them strokes, has to go into the nursing home, and they apply for Medicaid, and if they're eligible and the spouse that's in the nursing home is getting state benefits, then when that spouse dies, and let's say it's the husband, he dies, the state will notify the widow, we've paid $250,000 for his care in the nursing home, just so you know that. Because when you die, ma'am, you're still in the house, we're going to make a claim in your estate. The state comes first on that. Well, expenses for funeral now are protected first, cost of last illness, and administration expenses, which means the lawyers get paid. The state acknowledges that they need the lawyers probably to help the people get through it, so the lawyers get paid, but then the state has a claim for those benefits. So really, that's kind of like what the Special Needs Trust does. If that money belongs to that person who is disabled, and when that person can get the benefits from the Special Needs Trust, but when that person dies, that money will go to the state to the extent that the state paid benefits for medical expense. So that's how the special needs, and what can you, it should not say, whatever you do in that Special Needs Trust, do not use the word support. What they've got is, if it's called proper care, maintenance, support, and education, even if they say it's at the sole discretion of the trustee, if that support word is in there, it's death for Medicaid, because they're going to say, nope, you got to use all that money up first. That word support, it's a support trust. That means that's going to go for paying for Medicaid benefits. That's going to go support for housing and everything else. You can't let the state pay that. They're going to tap it. Yes, sir.
If you establish a trust for special needs, are you saying you should do that, but maybe not to a big extent? So then the state can't come get that amount? I mean, like, say, put 10,000 in instead of 50 or something like that?
Mm-hmm. Yeah, and if it's your own money, yeah, then you can do whatever you want, because you could do 10,000 or 50 or 100 if you knew in the end it's going to go to your own, your other kids or the grandchildren or whatever. But if it's that child's money, you don't get a choice about that. It has to go to the state when that person dies.
Can you repeat the questions just so we can?
Oh, yes, thank you. The question, let's see.
It's
A
hard.
good memory is just short. No, the question was, can you fund it? Should you fund it then only at 10,000 so the state doesn't get as much money?
Oh.
So that's a good question. And the answer is yes. If it's your own money, you can put as much as you want or as little as you want. But if it's that child's money, like they inherited, then you don't have that choice. Whatever money that is, if it goes into a self-settled special needs trust, then that money must be arranged in that trust to provide back to the state if there's any money left when it's done. In fact, that's the first case I ever ran into, and it was probably 2 decades or longer ago. A grandpa had deeded property to his children, but one of the children had died, leaving a special needs child. And she was an adult, I'm thinking 30 years old or something. She had all the wonderful benefits that she got with Medicaid and employment and housing and everything else. Well, they're saying, wait a minute, you've just inherited money. You're not eligible anymore. Thankfully, we could take that money and set up a self-settled special needs trust. Nothing changed for her. She still had all the benefits, but then she had this enrichment from these funds, from the special needs trust. But when she dies, that money will be first capped by the state. It was her money. And fortunately, they didn't kick her out of the work programs, kick her out of the housing, take her off Medicaid, you know. Thankfully, we could do that. There's a very good lawyer up at the state, Tim Austin is his name. He used to work in Mandan, but he works for the state and he works in this field. And he is a splendid fellow because he's honest and honorable, and he'll tell you right away if this is one where they have the claim or they don't. I like to work with him because he and I work enough often together with these things that we know we'll only speak the truth to each other, and it's not game plan. He's a very good fellow for doing that. And I really admire him. They'll lose a good man when he retires. But it's nice to have people there that you know you can work with, that can talk to you about. So you can use the benefits of that to, it supplements their living situation. It doesn't supplant it, and that's the key words there. You can use it paying education, recreation, entertainment, counseling, transportation, medical care that isn't covered by Medicaid. For example, dentists, for example, I think there might be restrictions on that, whether or not they'll get covered. They buy a van. I think of the one where the family wanted to take a trip to Disneyland, and they could use the funds from the Special Needs Trust to pay for the ticket and the housing and the meals and all the entertainment for the Special Needs Child, which is splendid, you know. It didn't, no way Medicaid would provide for that, and that the money was there to improve the benefits for that child's life. So it's a good deal, and special needs trusts really are good. And I said, self-settled means you use that child's own money, and then the state will get it at the end. Or a third party, which if we establish it out of our money for the benefit of that child, then when that child is gone, then you can say, now I'll tell you where that money goes.
I have a question about that. So, like, if you have multiple children, would it be more beneficial to say child A will get, I'm just going to use $10,000, and $5,000 of that is to go into your child with special needs trust, because then it's not an inherited? And
Yeah.
then would that be?
Now, are you talking about like while you're still alive creating?
No, like if, right, create that while you're living and then you die, you have multiple children. Would it be more beneficial to not leave the child with the disability any money and have it say your whatever child would get the extra portion, it's directed to go into that special needs trust?
Yeah, well, you could, for example, if you establish a special needs trust now while the child is alive, then in your will you might say, okay, what's left, I'm going to take 80% of the money and give it to the other kids.
Right.
And I'm going to take that 20% and I'm going to do it in a special needs trust for the benefit, not the one you've already created. Or it could be the one you've already created. You could be the one you've already created because that's your money in the first place, if you did it while they're alive, and your money. Yep, you could do that.
Okay.
And then again, you could say, and then when that child dies, his or her siblings are going to get what's left. Or if they're gone, their kids will.
Sure.
Yep,
Okay.
yep. So I think your question was loud enough. Did everybody hear it well enough? Do you think we got it? Okay. The cameraman has been gracious enough to let me know if I don't speak loudly enough. So, the disability on those special needs trusts is defined age, blind, or disabled, and disability is unable to engage in gainful activity because of physical and mental impairments expected to last over 12 months. And that's like SSI and SSDI. Again, With SSI or SSDI, it's not a $3,000 limit like Medicaid, it's a $2,000 limit. But again, if you have a special needs trust established for them, that should not be counted in there. Now, an ABLE account is another option to do it, and I think some of you are more familiar with it. Mrs. Romanek was kind enough to suggest that I brush up on that, because I don't have a lot of clients with those, very honestly. When they first started those 529 accounts, they were intended for college. They were funds for college, the traditional 529. But then they made the 529A or ABLE, which would be for it's achieving a better life experience, and that you can put in up to $100,000 for the benefit of a special needs person who qualifies because of those disabilities or whatever. And with a regular college fund, you can start out saying, I'm going to put 5 years worth of my annual contribution and fund it that way. But with an ABLE account, you can't do that. If right now you can give, this year now, $18,000 per year per donee. I could give each one of you $18,000. I wouldn't have to file a gift tax return. My wife could give each one of you $18,000. I wouldn't have to give you a gift tax return. My wife and I could both put $18,000 or $36,000 a year into an ABLE account, and then, we can do it until it gets up to $100,000. But we can't give more than that in a year. That would be a disqualifying excess amount. So that's how an ABLE account works, and you can do it up to 5 years. But you can't get more than $100,000. The income that it earns is free, as long as the money is used for a legitimate purpose for achieving the better life experience. It's not taxable to the beneficiary. But if the beneficiary uses it for something that would not be appropriate, then the beneficiary can be taxed on that, income tax. So, and basically, it's pretty broad. You can use it, it says used for qualified disability expenses, which is expenses relating to living a life with disabilities. But they've got it pretty broad. Education, food, housing, transportation, employment, training and support, assistive technology, personal support services, financial administration. The thing that's interesting is, to the extent that it allows for housing, it will affect SSI and SSDI, because that is part of that is for housing. And so I've run into a situation where they said, no, wait a minute, if you draft a trust that has housing money in it for the benefit of this person, and this wasn't a special needs trust, this person developed a disability after age 26. If their mom created a trust for her benefit, if it provided money for housing, she would lose her SSDI benefits. So that's kind of a strange thing about that. And I think actually the same thing would be true of a special needs trust, is that if, to the extent that they're using that for housing, if they're on SSI or SSDI, that could jeopardize those benefits. And it's interesting because one of the things I read in preparing for this said, oh, it's great, use an ABLE fund for that. But another thing I read, which I think is a more authoritative, said, no, you can't. If there's any money for housing, it will jeopardize SSI or SSDI. So that's a caution. That's the thing to be aware of. Again, with the ABLE account, the money at the end has to go to the state of North Dakota or wherever state has paid benefits for Medicaid. So like the self-settled special needs trust, that money will go back to the state first when they pass it. Again, that's the beauty of it. The best solution, I think, if you can afford to put money into a special needs trust, is you put your own money into it. You establish it, because then you can say, this is going to improve this child's life. There's going to be benefits there that we can, and if we use it all up, so be it. But if we don't, at least we can decide where the rest will go. And it can go to the siblings, or it can go to grandchildren, or it can go to charities or cousins or whatever you want. But that's one of the nice things about those kinds of third-party special needs trust. But both the ABLE account and the self-settled special needs trust require the state to get that money. So that's problematic. I think it's North Dakota does not, there's a pooled thing too. You can have a pooled resource fund. And I thought for GAPS, Guardian Protective Services might have had that. Does anybody know on that? Has anybody worked with GAPS on that? It seems to me they had a pooled thing. You can, instead of, so if I set up that trust, a lot of times it's a sibling. The sibling will be the trustee and manage the money for his or her sister or brother. But you can use, sometimes it's a pooled one. North Dakota, I think, does not have that. The state of North Dakota doesn't have it. But you can, with the ABLE account, you can go to any state that has it and, handle that. There's some reporting requirements and things like that. As I say, I can't think of one single client that I have that I know of that has an ABLE account. And I've not really dug into it. But I have had, in fact, what's interesting about the Special Needs Trust, if a child is over 26 and then starts to have issues, and it might be chemical imbalances, it might be addiction problems, I can do in a will, say, they're gonna put money aside for the benefit of that, but it's like a special needs trust. It's solely at the discretion of the other sibling or maybe a trust company to put money in there, and they don't have to put a dime in there. So if that person is now eligible for SSI or SSDI, they're not gonna be losing the benefit of that, but they're also not going to get their hands on a bunch of money. It's interesting with the years of experience. I mentioned my trust was what we established at 22, 25, and 28. Years and years ago, I had a lady that she knew these boys were troublemakers, and she said, I'm going to tie it up until they're 40. Well, by golly, when she died, we knew they were close to 40. And so we figured one thing we're going to do is we buy a bunch of treasury bonds, e-bonds. Because then there's, they don't get all the money, but within 6 months, those guys turn 40 and they spend it all. And I thought those, that would have been a perpetual trust you'd had for them, because those guys were not going to let a dime go unspent if they could do it. And I'm sure they spent more than their own. Yes.
Like, I'm thinking about the mechanics of a special needs trust. Like, who do people typically name as the executor? We have one other child, well, like young adult now.
Yeah.
So who typically can you name a bank? Do you name a friend? Who is? If the surviving sibling, the other sibling, if you have one, if he or she is capable of doing it and willing, it can be a burden though. So typically when I set that, a lot of times it is a sibling. And as I mentioned, my twin brother, when we were young, would have been the trustee for our daughter. But if he had not been able to do it, we named one of my wife's siblings. And because at age 28, she would be supposedly getting what was left, we figured that one of them would still be alive or be able to manage it. So a lot of times a sibling, but it can also put a lot of pressure on a sibling to do it. If you have a really good, reliable friend that's not going to be too old or willing to do it, it's a lot to ask, and it's kind of usually people don't charge for doing it, if they're family or friends, that kind of thing. If you work with a bank, they might be a little anxious about doing it. And some of these banks, and there's some good trust companies, I've worked with a number of them, some of them will say, okay, we'll do it, but it's going to be $1,500 minimum a year for a fee, plus we're going to charge based on the percentage of what the assets are. And again, that starts eating away at the principal. So if you have the ability to name somebody that's in the family, or maybe, a couple of people, and a lot of times you can find somebody in the family that really is about as sensible as a person you can get. Now, I don't recommend you get the person that is so tight that they can make a mile of copper wire out of a penny. You don't want that person. But you also don't want somebody that's so weak that they come in and ask for money because, I want to go to a movie, okay, here's $100, go to the movie. You can't have somebody do that either. And it can be a burden, but if you can't handle the burden, fine, we got an alternate name. Or you can find an alternate and name an alternate. And if that means it's a bank and it has to be a trust company and they have to get a fee, then so be it. But there are some really good, I've worked a lot with It was American Trust Center, now it's Bavera Bank. They have some very good people there. US Bank has a trust, Wells Fargo Bank, but Wells Fargo now is doing a lot out of Fargo and Minneapolis and stuff, so it isn't quite as easy to work with them. And I just had an estate now where Wells Fargo was named as the personal representative of a will. And they said, I don't know, if the assets aren't worth at least $1.5 million, we're not gonna touch it. So they declined, and one of the other family members now is gonna serve. Which to me is interesting, you know. Yes, sir.
Excuse me, do you need an attorney for special needs trust? Run that up?
You don't have to. I think there's a form somewhere on the state if you search for those forms, but I certainly recommend that you do at least have an attorney review it for you. One of the things, I had somebody come in one time, a dear sweet old gentleman, and he just wanted me to look at this power of attorney that he drew. And he said, would you mind looking at this? And I said, no, I'd be happy to look at it. And I looked at it and I said, well, what is it you want to do? And he said, well, I wanted my sister to be able to, you know, do things for me in case I couldn't. And I said, well, the form you signed her, or you want to sign, gives her the power to sell your house, and that's it. So, you know, it was a good thing that he brought it in, because that wasn't his intent. If he had a stroke or something, that'd be one thing. But, so I do recommend you do check with a law firm or, you know, a lawyer that you know and say, would you mind looking at? Some lawyers don't like doing this kind of work, and I understand that. Everybody has their own interests and stuff. But some of us really like doing this, so, yes.
I'm interested in finding out more about setting up an irrevocable trust. So can you just kind of walk us through the steps of what it is and how you would set it up? And
Sure.
From the very beginning?
Yep, so if you came into me and said, you know, we have this farmland and we want to be able to protect it from Medicaid, for example. So if we go in the nursing home, they don't make us sell all the farmland or whatever. And that's kind of a standard, a typical thing that I run into. So the irrevocable trust said, okay, mom and dad are going to put this land into this irrevocable trust. And the provisions of that trust say that as long as we're alive, all of the net income comes to us. And the net income would be the trustee, whether it's one of the other kids or even mom and dad, although I prefer to have somebody else be the trustee so that the government doesn't say, wait a minute, you know, you're just playing games. But the trust collects the rent from the land, if you rent it out, pays the real estate taxes, insurance, and that light bill that comes out every month for the yard light, and then the net income goes to mom and dad. That trust, then, irrevocable trust, says when mom and dad are gone, then this is how it will be distributed. And sometimes with minerals, what we're doing, we're saying mom and dad get the income for life. When mom and dad are gone, our kids get the income for life. And when one of them dies, it's going to go to their children, that share. But when the last of our kids die, then it will be distributed the minerals to our grandkids. And the reason that we finally have to have, we can't let it go on forever, is because in North Dakota, there's called the rule against perpetuities. You can't have a trust that goes on forever. Now, South Dakota has what's called dynasty trusts, and you can make a trust that goes on for eternity, which is a long time. But
So is it only the income from whatever is put into the trust? Like, I don't have a farm and I don't have minerals. So is it if we put money into an irrevocable trust, is it only the interest earned?
yeah.
So none of the principal can be distributed?
Because if you can get at the principal, then you're not protecting it from Medicaid. They're going to say, wait a minute, you can get that money out.
But if it's in an irrevocable trust, can that principal be used for the enrichment and improvement of the life of the person who has the disability?
Okay, now we're talking about special needs trusts.
Correct, and especially it's irrevocable trust.
And usually special needs trusts are irrevocable. You can't change it.
Okay.
Yeah, that's a good question. So the question was, if I have a special needs trust, is that irrevocable? Or that's basically, it is. You cannot change it. It says that as long as this beneficiary is alive, that money is there, including principal. That money is there for the benefit of that.
So principal can go to them.
Yeah, the principal can go to them, absolutely. And in fact, depending on how if you fund it with $10,000, you're not going to have much income on that, because even if you had 5% interest, you know, that's $500 a year, if my math is right. But, so you would want them to say, okay, my twin brother is doing this for me, He's got $10,000 in that account. There's a chance to go to a family vacation to Hawaii. He can take $4,000 out of that money and pay for my ticket and my hotel and my meals and stuff like that. He can use the principal as well. But as long as it's not, and it won't jeopardize my Medicaid benefits, because it's not something that Medicaid would pay for anyway. The state wouldn't pay for that trip. So, yeah, so the special needs trusts are irrevocable, and that's a good question, and I didn't make that clear. They are irrevocable. Although, if it gets down to where, there's only $400 left in there, at that point, you'd probably just say to the state, hey, look, we're gonna buy them a computer, and then we're gonna close this thing out. There won't be any money left.
So if we go to a lawyer and set up a special needs irrevocable trust, and I can direct things like insurance and anything, like if we both pass away, any sales from the house, any estate could go into this irrevocable special needs trust.
Yeah.
There's no siblings, and so if we get a trustee from Rivera or Massachusetts Mutual, they would probably be more of a financial, type on the financial side, because they're responsible for the financial security, right?
Right.
Is there a way to also appoint a different person who would be the person who would decide if they can get a new app or a new sweater or something?
Okay,
Can you
and
have
that's a good
two
question too.
trustees?
Yep, so if you have the special needs trust, and if you name a bank or a trust company, for example, as the trustee, can you have, and it's truly what they call a trust advisor. Now, I've never seen one in a special needs trust, but there are trusts that are established, and I'm not saying you can't do it, but a trust advisor which could tell the trustee, hey, it's time to put some money into this or that. And actually, you'd make them co-trustees, that's what I would do. You'd make them co-trustees. Say, my cousin John and the bank will be co-trustees. And the bank is gonna be responsible for, doing the investing and stuff, and they'll get their fees. But my cousin will be able to say, it's time for us to, he needs a van for getting around, and no else can get that any other way, we need a van. Or, as I say, a trip, or he needs a new computer, or, an easy chair. And I've seen them for just good clothes, that are comfortable clothes that might not be available yet.
Yeah, I can't imagine the baker wants to deal with that.
Yeah, and actually, and I actually had one banker one time say, well, I don't know if I should be getting money for that, and go, whoa, you've forgotten what the purpose of this thing is. It is to benefit it is to benefit, enrich, I think of it as enriching the life of that beneficiary. So, that's a good question.
This is a question that comes up a lot. Like, so I come to you and we set up a special needs trust. Like when we had that done, the attorney said, go open a bank account at, it says that irrevocable third-party trust for Elizabeth Vermonic with $100.
Yep.
So now I have to put $1 in like every 6 months just so they don't close down the account, right? But it's not, and so I know somebody else who I think Casey did it for them. They said just attach a dollar bill to the paperwork for them to open the account up when you die. So like what, like if you're not, like our thing is, it's a vehicle to catch the estate when we die.
Right.
And so I don't know that we'd have to have this checking account even open. That part just always seems clumsy to me.
So,
what do you do at this point?
Well, that's a good question. And if the special needs trust, if I want to fund it now, I can start it with $100, open a checking account for $100. And then, and as you say, if the bank is saying, gee, there's been no activity, we're going to close it, okay, well, here's another $50.
Then I have to tell SSI,
Or I'll
I
write
have
a
to
check.
tell Medicaid that I put $1 in and it's not Elizabeth's money,
Right.
it's my money, and I have to prove that I put this $1 in of my own money.
Yeah.
So.
But then you can say, and so that account is in existence then,
Okay.
so that if your will then says, when we're gone, we have 2 kids, 50% is going to go to the one who's not special needs, the other is going to go into that special needs trust. then that vehicle's already there to put the money into. So once the funeral expense and all those are paid, then that money is divided and distributed and the estate is closed. So,
But you wouldn't have to either. You wouldn't have to open an account necessarily.
no, in fact, you could just say in my will, at the time I die, when they're ready to distribute, now, 50% of my assets are gonna go into this special needs trust, the Clark Bormann Special Needs Trust, and 50% are gonna go to Kent Bormann. My twin brother's actually named Kent, like Clark Kent Superman. But he's an hour older than I was, so they never thought about that. It was 3 days later, somebody said, just like Superman. And I always remind him, I said, if it weren't for him, if it weren't for me, he wouldn't be a twin. But anyway, so that would be a way to do it, is the will says, take half of the money, put it into Clark's Special Needs Trust, which now the will is creating, and then the other half goes directly to Ken. And that way, then the personal representative of the will, when they're ready to close the estate, is going to go down to the bank and say, here, we're opening a Special Needs Trust, and I'm the trustee, and this is the way it's gonna be.
But we could be putting $1,000 in a year, right? But
Yep.
then is there tax implications?
Nope.
Not?
And as long as you can give, as I say, you can give $18,000 in there each year if you want to. You can, and
Oh,
your
not
husband
in the
can.
able account.
Well, either one,
Oh,
yeah. Into the Special Needs Trust, you can put any amount in the Special Needs Trust. But technically, to the extent you give more than $18,000 at any one time in 1 year, technically you're supposed to file a gift tax return. But I always use this as an example on gift tax. Because right now, the gift tax and estate tax it's linked. It's $13.6 million. If I gave my daughter $100,000 today, I would have to file a gift tax return and say, Uncle Sam, I gave my daughter $100,000. The first $18,000 doesn't count, but you have to take $82,000 off of my $13 million credit. So just so you know, when I die, I don't have that full 13 million, I've only got 13 million minus $80,000 or something. So it's not that big a deal. It's simpler if you do, yes.
Okay, I have a couple of real basic questions, so if they're
Yep.
off, you can.
they're gonna help somebody, Vanessa.
Okay. A special needs trust, is trust another word for like savings account?
No, a trust really is an instrument, it's an entity which says, I am the trustee and I am holding assets for the benefit of a person.
Okay, so,
And I have a fiduciary duty to make sure I don't use that money for anything else. The funds I have might be in a savings account, or an investment account, or even a checking account.
okay, so I put money into this account. Is it under my name or her name?
It's called the
It's just called
Daughter's
the trust.
Special Needs Trust. Yeah.
Okay,
So start with the
With
document,
instructions.
create the trust, and then you go into the bank and you say, I'm gonna open a special needs trust. So that would be the name of the account, Clark Bormann Special Needs Trust.
okay,
And your just checking account would be fine.
okay.
It's almost like a business account.
Yeah, it's kind of like a business account.
So it's separate entities.
That's a good
Like,
way.
yeah, I just asked.
Okay.
And the money.
That's a good
It's
question.
not Clark, it's not Clark Trust, that would be your child's name, right? Because you used your name.
Yeah, I use my name
Yeah.
because I would be the beneficiary of her trust.
Oh.
She's gonna open one for me. Yeah, but it would be the name of the child, yeah.
Okay.
The child's special needs trust.
Trust.
Yeah.
And can it only be accessed after I die?
No,
So like if I start this today,
yeah.
she can go in there tomorrow and be like, I need a new shirt.
No, she doesn't do it. You are the trustee.
If she was 18.
If she was 18?
No,
How does this work?
No, it means that only the trustee. The question is, how does it work? So, if you came in to me and said, Clark, I need a special needs trust for my daughter Annie, we would create, a document that you would sign saying, I am creating the Annie Special Needs Trust. And then, you could go down to the bank and say, okay, I've got this trust, and here's $100, I want to open a checking account, the Annie Special Needs Trust account. Then you're the trustee. And then if you decide Annie needs, a new computer, then you can use that money to do it, and it won't affect her Medicaid because, it's your money. It's her money, but she doesn't have access to it and doesn't count against her. for that.
She can't get into it. Okay.
Why can't they get focused on your dad?
Can there be more than one trust per child? There can, if, for example, let's say the child had money, the child might create his or her own special needs trust, the self-settled one, and then mom and dad might create one themselves. If the child does it with his or her own money, or if mom and dad do it on behalf of the child, that money will end up going to the state. So make darn sure that the money that you guys contribute is a separate trust, because then that money will not go to the state when that person dies.
But what if one set of grandparents open up one and another set of grandparents open up one for the same child?
They can do that.
Yeah.
Yep.
You can only, individual can only have one able account.
Able account, that's right.
You cannot have more than one able account.
Exactly. Yep. And that can't have more than $100,000 in it.
Right.
So.
Well, you can, but then you're gonna get disqualified from your public benefit.
Yes, right. Plus, you can get a 6% penalty on the amount that exceeds $100,000 if you don't distribute it out back to the donor.
So just don't be too rich.
Yeah. Don't be too rich, yeah.
Yeah.
They say the perfect estate plan is when you're ready to die in the hospital and the last check you write, which goes out your account, pays the doctor.
I'm laughing every time you mention mineral rights, because when we sat down, we had to list like all of our assets, right? And so then the attorney turns to me and says, well, now Roxanne, we've split everything between your son and this trust. What do you want to do with these $36 worth of mineral rights from Lemoore County? She said, I would just say that you just give them to your son. Let's not worry about him in the trust.
Yeah, make it simple. He can always make it right.
Yeah.
So I have a question that's, it's sort of like a way to possibly use an irrevocable special needs trust. We had a kid come to Bismarck years ago as the keynote speaker for a conference, and he had Down syndrome and autism, and his parents had started a business for him that sold popcorn. And his popcorn business made enough money and paid into his special needs trust that it paid for the accountant and the lawyer and the and the co-trustee and the trustee and so and I think they talked about, I can't remember if they had bought him a house, and so it's sort of like, what's the limitation of the use of a irrevocable trust? Would it have that same impact on the housing or SSI or?
Well, to the extent that they're buying a house and stuff, yeah, I think SSI and SSDI, he would be eliminated from eligibility for those, as long as he has, those assets are used for housing. But to the other extent, if it's used for other things, I don't know that, because they're not supposed to count those assets against him, because he doesn't own them, they're in the trust. Yeah, but the housing part would be problematic, I think I'd
I
agree.
think you could purchase a home. Like if you saved enough money for a down payment in your ABLE account, let's just say you could use that to purchase a home. They won't count a home against you for SSI or SSDI.
The
You
residency
had home
factors,
ownership.
yeah.
It won't.
So it's like if you started a group home or, bought a home that a couple of kids could live in or whatever.
Now that's a whole other conversation,
I know.
I think.
But the SSI
That's
wouldn't
probably gonna be
pay your
yours.
guardian.
That's gonna be somebody else's property and not that individual's property.
Could it be the trust?
Or the.
Could a trust own a home like that? I suppose the answer is yes, especially if the trust could. And again, it's your own money that's funding it, right?
Right.
It's not the child's money. I don't know why I couldn't, but boy, I'll tell you.
There's also some ways to use Social Security products to fund types of things that are going to further employment, for lack of a better way to talk about it. So there's, outside of this, there are other vehicles through Social Security that incentivize employment. So.
There's one thing too, just because of the Secure Act, they changed, usually if I inherited an IRA from my father, I used to be able to say, okay, I'm 71, I can take that over my life expectancy. They changed that law, they said, no, you gotta take it within the next 10 years. Except for the special need, or for the disabled person. They now say a disabled person can take that inherited IRA and spread it over their lifetime. They didn't make an exception for that. But again, I don't recommend leaving those assets that way. Put them into that special needs trust.
What would be the pros and cons of, let's say, a grandparent setting up one and us individually setting up one as parents, or putting one together?
I think actually, just use one. And if they want it, but again, it's not the child's money. It's
Right.
yours and grandpa and grandma's money. Yeah, just use one. And then that money is there for the benefit of that child. And then you and grandma and grandpa can decide, what do we want to do when this child passes away?
Can both sets manage that then, like her mom and her?
Yep, you could be the trustees of that.
I think if money goes in there, it's just like I just said about reporting to Medicaid and SSI, every time I put $1 in there, they just really want to know that it wasn't the person's money that goes in there. So I could put money in.
So how often, if you were just putting it in?
I'm just putting it in every 6 months so the bank sees there's activity in the account.
But- So you're having to file it with every 6 months?
Every time?
Well, I'm sending in, twice a month, I'm sending information into them with pay stub information and everything.
But
So.
that's because of the able, right?
No, because she works.
Oh, okay.
And she has
Okay.
SSI and
Oh.
and Medicaid, so
Okay.
I report every time she gets paid. But she don't want me to talk about it. I mean, it's like, well, it's cheap to get the pay stub out of your roll.
So what about like life insurance benefits and stuff? Because now that I'm thinking about that, so like I have any kind of life insurance or any of that I have like set up through my job, I have 100% goes to my husband, and if he's gone, her. I should not do that?
No, it should be, if he's gone, then into your estate, if your estate is going to create the special needs trust. Otherwise, it should go to that special needs trust.
Because then it would be her money, right?
Yeah, and
Right.
then
That's
like
what I-
she has Medicaid now, but then she would have a big recipient liability if something
Okay.
happened.
So I have
Yeah,
to
you
take
definitely don't want her to be the beneficiary.
Gotcha.
And same with grandparents or aunts and uncles.
Right.
You don't want them to
Sneaky
leave-
people out
you
there
don't
that
want-
you don't
You don't want them
know.
to leave any money in her name.
Okay.
It should go into the trust.
Did you have a question, Linda, or did I answer?
Oh,
okay.
I have a question.
Yes.
Did you say that on a self-settled special needs trust, those dollars can go for a funeral and the lawyer before
think
the
that-
rest goes to the state?
No, on the, let's see, funeral, or what did you, what was the other thing? Oh, the lawyer. No, that, actually, no. That's if there were a regular, just probate. I was talking about just probate there. If I'm in the nursing home and Medicaid is paying my rent, and then I die, they tell my wife, when you die, you're gonna have to pay that back. But when she dies, first the lawyers get paid and the funeral, then the state gets it.
So that's just in the regular estate?
Right, right.
Because they don't have something like that up to the self-settled.
Correct. Medicaid gets the first
Oh,
shot.
look at this, we all start chattering.
Oh, thank you. Yeah, the question was, and I maybe wasn't very clear on that. The question was if I talked about the funeral expense being a priority and the attorneys, the cost of administration, but that wasn't to deal with the special needs trust. If it's a self-settled special needs trust, Medicaid's first at it. The funeral doesn't get in there, and no, take that back. No, I think funeral will get in there. I think they can pay the funeral expense out of the special needs trust. Yeah, that can. But what I was talking about in that case was if I went into the nursing home and was a Medicaid recipient, when I died, my wife would be notified, we paid $200,000 to take care of Clark. Just so you know, because when you die, Mary, we're gonna file a claim against your estate. So then when my wife dies, she's still got the house, they're gonna say, fine, sell the house. The funeral can be paid and the lawyers can be paid, but the state gets the next dollars. So. And the
There
state,
is a way that you can set aside money for funeral expenses.
yes, You certainly can. And it used to be a limit, it was 3,000, then it was 6,000, but right now, the rule in North Dakota is, and I tell people this regularly, if they're talking about Medicaid planning, you go into the funeral home right now and you put $12,000 down or whatever you think that's gonna cost. It's irrevocable, I mean, it's a trust, I mean, they have the money, it's not yours anymore. If that funeral home should close or something, it'll go to another funeral home. Or if you choose another funeral home, the money will go with it. But that money doesn't count against you when you apply for Medicaid.
So you can put any dollar amount on?
Yep,
So
yep.
it's not the 6,000 anymore, you're
No,
saying?
right. But to the extent of this, now, so if I put 12,000 in there, and then my wife does the funeral and it's only 10,000, the state's gonna get that other 2,000, you know. So make it pretty close to what you think it's gonna be. And funerals are expensive.
Right.
And it'll move to a different funeral home?
Yeah,
if-
yeah.
So they just hold your money for?
Yeah, it's in an account, and it has to be in order to protect it from that. So with Medicaid planning, I tell people, get that pre-planned funeral, get that done. Yeah.
So could you use Eagle money for the funeral expenses? If we've already put 6,000 in,
Yeah.
okay, we've got that. Can we use his Eagle money then to fund another 3,000 or 4,000?
Before the state would claw it back, I mean, but you would have to pay it,
Yeah.
is what
What do you
Clark's
mean?
saying. Well, I think he's saying you have to pay this out, this amount.
That money has to go to the funeral home. It's held or in an
Right,
account.
but we could take money out of his Eagle account, the $4,000.
Yeah, I
if we wanted to
think
add to
funeral
his
expenses
funeral
included in
expenses.
that, on the table. And funeral and burial, yeah.
So we could do that, okay.
And that's,
Seems like it's not enhancing his life, but I'm just kidding.
Afterlife.
But yeah, no, you can. It just, it takes a long time for them to settle those able accounts after death.
I suppose, yeah.
But, yeah.
And you know, it's interesting, my dear old dad, lawyer, he said, you know, every time I see that funeral director, he said, last guy's gonna let me down. It was awful cool. He lived to be 100. And on a cold day like we've had in the last couple of weeks, he said, today we killed a lot of bugs. Great sense of humor. Yes, go ahead.
Are you able to tell us what this costs?
Oh,
Like
that's a
if-
good-
Like to have if it's Bravera or Mass Mutual or whoever, I mean, to have them do that, what is a typical annual fee and what is the percentage that they take?
Okay, so the question is, if a trust company handles it, what fees do they charge? And my experience tells me that typically it's a minimum of $1,500. And then they charge a percentage based on the value of the assets in there. So if it's only $1,000 in there, you don't have them do it, you can't afford it, you know. If you've got $100,000 in there, my guess would be $1,500 a year, plus they would probably charge, if it's $100,000 another, say 4%, which would be another, what, $4,000. But they also would probably generate 5 to 6% on the money. So I mean, it should kind of at least hold its own. Now, to the extent that you spend down out of that, then, you know, then that fee proportionally goes up.
Do you think 4%? Is that?
I think that's what it is. It kind of depends on, you know, and actually there's some good, Mike, if you ever called Mike Seneschal is the guy's name at Bravera. And he's very capable, he's a good-hearted guy, he's a good man, and I think he would be happy to sit down with you and talk to you about doing it. If we would do it, how much would they charge? And I have had good luck working with them. I'm not picking on any of the other banks, but if you ask me which one would be your first choice, that would be my first choice. I guess I am picking one.
Well, I think we could probably be here all night, probably.
Are we doing
Then we
all
have
right?
like table talk and, yeah, so, but thank you so much.
Well, thank you for having me.
Yeah,
I'm glad I
thank you.
could come in.